Hi guys, so this morning in our consult section, I realized I'm an idiot and I forgot to include the breach of confidence and privacy content in the review lecture that I recorded over the weekend. So this video is just to really quickly update you on those two areas of law. So this video is a supplement to the review video that is already available on Blackboard. Okay, so confidentiality. Confidentiality is actually really easy. There's essentially three elements. So the first two are where you would spend the majority of your attention if you had this in an exam. So firstly is, does the information have the quality of confidence? This just means, is it evident from the facts that this was a secret or that this was confidential? Usually this means that it hasn't, there's some facts that will say that this hasn't been told to many people, it's been kept only to a couple of people, and that will indicate that it is a secret or confidential information. The second element is whether the defendant acquired that information in circumstances that gave rise to an obligation of confidence. So would the defendant understand them to be bound to keep this information secret? Now, again, just look at the context. They've either been told to keep it a secret, or it's obvious, like a reasonable person would understand not to go around telling everybody this secret, or they've acquired it surreptitiously, so by eavesdropping or sneaking into somebody's land and taking photos, that sort of thing. Those are where the facts are likely to give you some indication of how to answer those elements. The rest is really straightforward. So the third element of establishing the action is whether that information that was acquired confidentially has then been either used or disclosed. And if it has, without the consent of the person who gave the information, then that is a breach of confidence. There is one exception to that, or one defense. It is called the iniquity rule. And that says that you can disclose confidential information if that is to prevent fraud or a crime, or to protect public health or safety. But in any other situation, the information has to be kept confidential. And if you disclose that information to somebody else, or you use that information, then that is a breach of confidence. If somebody has committed a breach of confidence, then the remedies are, like in any other legal action, injunction and monetary damages. And that's it for breach of confidence. All right, privacy. Privacy, I understand, was a bit of a hodgepodge of different laws, so I don't want you to stress about that. All you need to know is what I'm about to cover in this video. And the reason we have a hodgepodge of laws is because Australia does not have a personal privacy right. We have what is called information privacy, and we have communications privacy, and there are two different laws that govern each of those things, and that's what I'm going to take you through right now, and that's all you need to know for the exam. Alright, so information privacy is governed by the Privacy Act. This is a federal piece of legislation, and it only applies to government agencies or to organisations. So it doesn't regulate individuals, but it does regulate organisations and what organisations can and can't do with people's personal information. Personal information is basically any identifiable information about a person. This includes their contact details, a photograph of them, but more importantly, things like their financial records or their health records. And what the Privacy Act does is it sets out a series of principles which are called the Australian Privacy Principles, or the APPs for short. And these basically say that an organisation can only collect personal information, use personal information, or disclose personal information if it is necessary for their functions or activities, and if they have the consent of the person about whom they are collecting that information. So for example, a hospital obviously has to collect health information about you. They'll ask you a whole bunch of private or personal questions about the state of your health, but they need to do that for their functions, to treat you medically. And so they are allowed to collect that because you consent to that and because they need it for their functions or activities. But they do have to securely look after that information and not disclose it to people outside the hospital, basically. And if an organisation breaches the Privacy Act, then they may have to compensate the people whose privacy they've breached. So that's information privacy. It's just really about those general principles. You want to look at that you're dealing with an organisation or a government agency, not an individual. That the organisation has collected, used, or disclosed personal information. And if they have, you needed to decide whether they were allowed to do that or not. So you look at what are their functions or activities, and did they have consent from the person to do that. Alright, the other type of privacy we have in Australia is communications privacy. There are two different laws. One is a Commonwealth law, federal law, and one is a Queensland law. And the rules here are also very simple. It's against the law to intercept a communication passed over a telecommunications system or to authorize somebody else to do that. What does this mean? This means you can't tap phones, you can't hack emails, you can't essentially hack into people's personal information over a telecommunications system, whether that is the old school phone system or internet system. The other laws in Queensland say that you cannot record a private conversation between other people if you are not in that conversation, and you also cannot use or share that recording. You can record a conversation if you are a party to it. So if you are one of the people in the conversation, you can record it, but you are not allowed to share that recording without the other person's consent. So this is all pretty common sense. The only exception where you can share that recording without consent is if it's in the public interest. So similar to breach of confidence, to prevent fraud or a crime or for public safety. So I've put a little flow chart on the slide for you, which is about identifying is there an unauthorized recording and how did they come about that? Did they hack it, or did they record somebody else's conversation? Or did they record their own conversation? It's only if it's their own conversation that they are allowed to make the recording, and even then they cannot share that recording without the other person's consent. And that's everything for breach of confidence and privacy. I'm sorry I forgot that in the other video, but hopefully this will help as well. Thanks everybody.